rip and rock my family over and stuff like that. What? What'd you say? My family's going to kill you, dude. No one they alright.
No one me.
Alright, Jeff. Little brother. One time. Yeah.
Yeah?
One time it all takes for this war.
And then it came out of the high chair.
I didn't.
That's stuck inside the high chair.
I didn't put that there.
Babe, it fell out of the high chair when you were coming around. It's the
That's childproof stuff.
On January 2nd, 2025, officers responded to a property identified on scene as belonging to the city. Throughout the encounter, the man in custody repeats one unusual phrase: "Kill me again. I ain't dead yet." That phrase is not just color. It raises a real legal question about his state of mind during the arrest.
Adam! Hey, stop! Quit moving around. What's going on? Adam! Hey! You're not going anywhere. Hey!
Put your hands behind your back. Put your hands behind your back. You can't undo that. Put your hands behind your back. You can't undo that. I told you to stop, Adam. Hey, no! No problem. You just did it.
Give me your other hand. Adam, you're under arrest.
I told you can't do that.
Your other hand, boss.
What? No.
One in custody. Yeah, turn time. Alright, sit up. Stand up. Stand up, Adam.
Yeah, but yeah, I ain't there.
Quit moving.
Kill me again, I ain't dead yet.
Huh?
Kill me again, I ain't dead yet.
I'm not gonna kill you.
Kill me again, I ain't. What do you say?
Stop moving.
What do you say, bitch? I said, kill me again, I ain't dead yet, boy. Kill me again, I ain't dead yet. Give me a cigarette, kill me again, I ain't dead yet.
You want me to light it?
Yeah. How do you light it?
It's a vape.
Yeah, how do you light it with that?
I don't know, Adam. Maybe you should have moved a little quicker. You gotta get away from me.
Yeah, that's what I'm trying to do about Saturday. How about that? The undone mission? Alright, it ain't done until I get that and go. Come on now.
Where'd this movie come from?
Well, where do you think? It's mine. Am I not smoking a cigarette?
No, you're not smoking a cigarette.
Can it not be mine? Can you not ring off it?
Well, I'll get you.
No, the other one. Full one.
What?
That full one.
Where? Right there?
Yep.
That's not full.
Yeah, it is.
Hey, Danny, you got a lighter? This ain't working. Can you light his cigarette for me if you don't mind? Alright, let's walk back over here.
Yeah, I'm trying to move out, but that ain't done yet.
Well, this ain't your house. It's the property of the city of Olney.
What?
So you're under arrest for at least criminal trespass, probably burglary.
You want to rip and rock my family over and stuff like that? What? What'd you say? My family's going to kill you, dude.
Why? Quit moving around, Adam. You're making this difficult on me.
What is that, Paul? No, you haven't got that one off my head, dude. Can't I got that, didn't you?
The core issue here is not the phrase itself, but what officers do next. an arrest for trespass with a mention of burglary. Under general trespass law, a person must remain on property without permission after being placed on notice of that lack of permission. The officer states plainly that this is not his house. It belongs to the city, establishing the notice element right on the recording. Burglary, unlike simple trespass, typically requires an additional element: intent to commit a crime once inside the structure. Nothing in the audio confirms that intent was established before the burglary reference was made, and that distinction matters if charges are filed. Under Atwater versus City of Lago, Vista, decided in 2001, an officer may arrest for a minor offense if probable cause exists. That means even a low-level trespass charge can support a full custodial arrest, regardless of whether jail time is likely. A second, separate issue appears when the subject says, quote, "My family is going to kill you," end quote. Depending on the jurisdiction, a statement like that can support an independent charge, separate from the trespass allegation entirely. Prosecutors typically weigh whether the words were conditional impulsive or backed by any actual capability to carry them out.
What's his name?
I'm Officer Sturm.
Yeah, no one they. All right.
No one fucks with me.
Jeff. Little brother. One time. Yeah.
Yeah?
One time the dog take food for him.
What? I've known you a lot longer.
No.
Got anything up there that's hidden that I can't find? All right, have a seat. Danny, are you the one that called? You didn't call? Okay.
He's been over there for a minute.
Was he taking stuff out from the house?
He threw all that right there in that file.
All this stuff?
The first, yeah. Probably. And there's a file. It should be a file up front.
Yeah, I seen it.
But that file right, that blue file right there.
Thank you.
You know? I just didn't want to know.
No, I thought they came out.
No,
You came around, I bet it came out of the high chair.
I
There
didn't.
was stuff stuck inside the high chair.
I didn't put that there.
Babe, it fell out of the high chair when you were coming around. It's the
Yeah,
baby.
that's childproof stuff.
I just wanted to make sure. I didn't.
He wouldn't have got so far, but I was trying to get a glove on. I didn't want to like tackle him without a glove
Make
on.
that pile there too.
I was right there at the door. I was watching. I wasn't going to let it get too far, but I didn't want to get in your
No,
way.
I appreciate it. I was trying to get a glove on as I was telling him to stop, and he wouldn't stop. I'm like, he ain't gonna get very far if I get the glove on, but.
On tactical grounds, one officer explains he waited to intervene until putting on a protective glove. Under Graham versus Connor, decided in 1989, the reasonableness of an officer's actions is judged from his perspective in the moment, not with hindsight. A brief delay for protective equipment while the subject is watched and not allowed to flee fits squarely within that reasonable standard. A third party enters the analysis here, a man named Danny, questioned about whether he placed the call that brought officers to the scene. Danny's answer that he did not call matters because it affects how officers document who reported the incident and why. Items removed from the residence are placed into a visible pile before any inventory, a standard step that protects the chain of custody. Whether that property lawfully belonged to the subject to Danny or to neither of them was never resolved on this recording. That gap matters because ownership of the items shapes whether this becomes trespass alone or trespass paired with theft.
You don't want to good. Don't move quicker than you think.
Yeah.
Adam receives a D+ because his verbal threat toward the officer created a separate, avoidable legal exposure on top of the trespass charge itself. That said, he ultimately complied with the handcuffing without physical resistance, which kept the encounter from escalating further. The arresting officer receives a B because repeated verbal commands were given before any physical control was used, consistent with a measured use of force sequence. However, without visual confirmation of a Miranda warning before questioning about items taken from the house, that step still needs verification. Officer Storm receives a B+ for maintaining a calm, rapport-building tone that kept the subjects talking without added confrontation. So is a verbal threat made mid-arrest treated the same as one made in a calm setting? Or does the context change the charge? First, a repeated command to comply, followed by measured physical control, is the textbook use of force sequence, and it holds up here. Second, a spontaneous threat made during an arrest can still be charged separately, even if it was never carried out. Third, when a third party's role is unclear, as with Danny here, officers should document that uncertainty rather than assume it away. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.